Welcome back. You're watching The Firm. Compulsory license is not an unmentionable word. Patent rights were created not in the interest of the inventor, but in the interest of the national economy. That's how Justice Prabha Sridevan, the chairman of the Intellectual Property Appellate Board of the IPAB, begins her order in the Natco Bayer case. And in doing so, she sets the mood for a decision that focuses on public interest first and inventor rights later. The IPAB's decision to uphold the compulsory license granted to Natco for producing Bayer's cancer drug Nexaware is the stuff that big pharma wars are made of. But this outcome will also set precedent for all other IP-driven industries. And so, to better understand the key aspects of this order, I have with me two of India's best IP lawyers, Himanshu Khane and Pratibha Singh, and joining us from Chicago is Chicago Law School professor Jonathan Masoor. To all three of you, a very warm welcome. I'm going to start first with you, Mr. Khane, and I'm going to start with the issue that's at the very heart of this case, that is, what is affordable pricing? One of the key grounds on which the IPAB upheld the compulsory license was that Nexaware was not available to the public at a reasonably affordable price. Justice Sridevan said reasonably affordable price necessarily has to be fixed from the viewpoint of the public, and evidence relating to the cost are not relevant. The entire concept of cost-based pricing, so to speak, if I may say so, Mr. Khane, has been thrown out. What do you make of this aspect of the decision?
Well, I feel in the first place, right from the opening of the relevant chapter, there are certain principles which must be taken into consideration, and those principles are really balancing both the rights of the patent holder and also at the same time the rights and interests of the public. That balancing act is very important. In that context, though the order talks about reasonable affordable price, I think it does not take into consideration the cost input in developing a particular invention.
That's an almost impossible thing to do, right? Pratibha Singh, come in here and talk to me about how you think this decision has looked at reasonable or affordable price, because, you know, as Mr. Khane argues, if you look at it only from the public consumption point of view, then many businesses would be put out of business.
According to me, 2,80,000 is unaffordable even to the millionaires and billionaires of this country. 2,80,000 per month is completely unaffordable to anyone, even to professionals or business people. So it was 2,80,000 versus 10,000. It's a non-starting argument, because any judge sitting there is wondering what will happen to the patient. 10,000 rupees itself is unaffordable according to me. So how is 2,80,000 affordable?
Professor Masoor, come in here. This has been at the heart of this debate for the last several years now. It's an unfair comparison because 10,000 is the price charged by a company that has copied the drug. 2,80,000 rupees in Indian currency is the price charged by the inventor. I'm not justifying the inventor's price, but I'm just wondering what this order leaves us with in being able to determine how businesses can do business, or whether they must do business only in public interest.
Well, I think that you're quite right that the order makes it clear that the court is not really interested in trying to strike much of a balance. It's much more interested in what would be affordable to the people of India than it is to what price the manufacturer, the patent holder, thinks is appropriate. I think it's important to note, though, that there are two sort of facts in the background that the court doesn't really talk about, but which I think are very, very crucial here. The first is this assumption, which I think a lot of courts and countries have, that all of the costs of inventing and researching and developing the drug are borne by American consumers, and that in fact the company is actually making plenty of money selling the drug for a higher price to Americans and to Europeans, and that therefore they don't need to sell it for such a high price in India. So that gets to your point about how to apportion the costs across countries. And the second point is that the American drug company, Bayer, is not just worried about what the price will be when it's sold to Indians. They're worried about people in India taking the drug and turning around and selling it back at a lower price to the United States. They're concerned about reimportation. And the lower the price is in India, the more likely that reimportation is to occur. So I think that there are sort of good arguments from an economics perspective on both sides, but the court didn't really discuss them in any great depth.
Pratibha, you wanted to add to that, because I would also say, if I was to stand in your corner, that irrespective of what we may think of pricing, the compulsory licensing aspect of the law is very, very clear, and it says affordable price from the point of view of the public.
Jonathan has raised two concerns, Menka, according to me. re-importation from India, that can be stopped very easily. I mean, NATCO has been granted a compulsory license only for India.
Correct.
I don't think they have the right to re-export to
They don't.
the
In
United
fact, they
States.
explicitly
I think
don't.
that aspect has been, yeah.
I agree with Pratibha on
So
that.
that aspect is taken care of. And coming to the query that you posed, that the judge had no choice in public interest, I think when the judge said that it is to be looked at from the point of view of the patient and the consuming public, she was right. She was not concerned either with the inventor or with the compulsory license applicant. And that's the spirit of Section 84 and compulsory licensing. You only look at it from the public interest point of view. In fact, if you, I'm sure Jonathan knows about this, if you look at the United States Supreme Court judgment in eBay, even when the US Supreme Court dealt with patent injunctions, they added a fourth factor to the three factors on grant of interim injunctions. They said public interest has an overriding impact in patent cases whether to grant the injunction or not. So we are not talking just about India. Even in the US and across various other jurisdictions, judges who sit in courts are more concerned about public interest.
Well, I have a point to add here that at the same time, we should look at Section 83, which lays down general principles, and it says that the balancing of rights and obligations must also be achieved. So here, it's not only the public interest that we must look at, we must also look at the balancing of rights of the patent holder. And here, if you don't encourage the patent holder to invent more and to come out with more inventions, then ultimately a day will come when nobody will spend monies on inventions.
If the law says affordable pricing must be from the point of view of the public, and it doesn't make any exception there for inventor costs or inventor rights, then I mean, it's very clear why the IPAB would rule the way it has.
But I think, just taking away few words from a section is not proper way of interpreting it. You must look at the whole scheme of the compulsory licensing. And just now I cited from Section 83 a certain portion which fits into the scheme of compulsory licensing.
The second ground on which the compulsory license was upheld was that Bayer did not meet the reasonable requirement of the public with respect to Nexaware. To support this decision, the IPAB cited Bayer's infrequent imports of Nexaware. But the board departed from the patent controller's order and conceded that local manufacture is not practicable in every case. It left the interpretation of worked in open, but also said a patentee must show why the invention could not be locally manufactured. Pratibha, you want to go first on the implications of the supply aspect of this decision?
Yes. See, first of all, I agree with Himanshu that patents are granted to encourage innovation. Having said that, there have to be different models followed for different societies. There is one inventor company which I am aware of, which has issued multiple licenses in India and is in effect collecting more royalty on its own without a compulsory licensing regime. So, when you start licensing your technology and your patents to multiple people, you increase the market base, you increase the reach of the drug, and then you increase the profits that you make by selling the drug and making it available to the public. Having said that, the IPAB has taken a very, very pragmatic view on imports. If you read the Controller General's order, it actually said in so many words that if the product is not manufactured in India, it does not amount to working. Whereas Justice Sridevan, in fact, has with her wisdom said, in a given case, even import could be working, it could be manufactured in India which is working. However, while you import, you have to meet the demand. There could be a company who is manufacturing in India such little quantities that you are not meeting the demand. So when she says that it has to be decided on a case-to-case basis, the concern which the innovator companies had that they had to only manufacture in India has been completely ruled out with this judgment.
I do agree with that. And I think that it's impossible to talk about the question of supply without talking about the question of price. I mean, the issue is just what percentage of the demand is the company required to meet? How many people must they be able to provide the drug to? And that just revolves entirely around the issue of how the drug will be priced and who will be able to afford it. So I think it does make sense that when we're talking, once we've decided what proportion of the population should have access to the drug, whether the drug is imported or whether it's manufactured in India, it doesn't matter.
What is the message that this decision or this order is sending out to inventors, to public, and to those who are interested in the commercial interest of the inventors, that is shareholders, stakeholders?
I will put it like this, that I feel that the pendulum has swung to an extreme end, which it should not. It should really maintain a balance between the rights and obligations of the patent holder against the public interest. I would expect that ultimately the question of the cost of invention she has brushed aside completely. So therefore, maybe for reasons because the facts were not before her,
That's
maybe
right. I think
because
in
the
fact
evidence
all
was
the full
not
facts
there.
were not presented,
I
right.
agree.
Yeah.
But I just want to mention that therefore in a case, if the proper facts and evidence is before court, then that is also a factor which should be taken into consideration.
Patent holders have to devise innovative methods of making the products more accessible. They should look at cheaper models of manufacture in India, cheaper licensing, and increase in the distribution pipelines by allowing more and more companies maybe in India under a license to manufacture this.
This is a momentous decision, a very important decision that goes further than just about any decision that's preceded it. I think that the message to pharmaceutical firms, to patent holders is very clear, which is you're going to be expected to meet the demand of the people of India and to meet the demand of people of other emerging countries, irrespective of what price you have to charge. And so if in fact companies like Bayer have trouble recouping their research costs, they're going to have to look elsewhere to find consumers who can pay for those research costs. So they may have to start charging higher prices in Europe or in North America if that's what's necessary to be able to make enough money to meet the research, to meet the demands of the consumers in India and other countries.
All right, we're going to leave it there for the paucity of time, but to all three of you, thanks very much for watching this edition of The Firm. We'll be back next week.